Can a game of skill become betting and gambling simply because money is involved? Should GST be levied only on the platform fee or on the entire amount staked by players? And did the Supreme Court just rewrite the taxation landscape for India's rupees 1 lakh crore online gaming industry? If these questions interest you, stay with me because today we are going to decode one of the biggest GST judgment of 2026, the Gameskraft Judgment delivered by the Honorable Supreme Court. Hello everyone, I am Jyoti Baluni from IDT Division of DPNC Global LLP. And today we will discuss the landmark Supreme Court decision in DGGI versus Gameskraft Technologies Private Limited. This judgment does not just affect online gaming companies, it also lays down important principles on actionable claims, GST valuation, constitutional validity, and retrospective taxation. Let's understand the case in simple language. Background of the dispute. For several years, online gaming companies such as Gameskraft, Dream11, Bazi Games, Play Games 24/7 and many others were paying GST at 18% only on their platform fee or gross gaming revenue. Their stand was simple. We merely provide a technology platform. The amount deposited by players belongs to the players themselves. The platform merely retains a small commission. Therefore, GST should be payable only on that commission. However, the GST department took a completely different view. According to the department, the gaming companies themselves supply an actionable claim arising from betting and gambling. Therefore, GST should be calculated on the entire amount staked by the players and not merely on the commission. This interpretation resulted in massive GST demands running into thousands of crores of rupees under Section 74 of the CGST Act. Various high courts granted relief to gaming companies by quashing several show cause notices. The matter finally reached to the Supreme Court. The legal issue before the Supreme Court. The Supreme Court had to answer some fundamental questions. Can online gaming involving stakes be treated as betting and gambling under GST? Are gaming companies merely intermediaries or they themselves suppliers? Should GST be charged only on the platform fee or on the entire amount deposited by players? Is Rule 31A constitutional valid? And finally, were the 2023 GST amendments merely clarificatory or do they operate only prospectively? What did the Supreme Court held? After examining the constitutional framework, GST law, valuation provisions, and decades of judicial precedents, the Supreme Court ruled largely in the favor of the revenue. The court held that first, Parliament has constitutional power to levy GST on actionable claims arising from betting and gambling. Second, once money is staked on the certain outcome, the transaction falls within the taxable framework contemplated under the GST law. Third, online gaming operators are not merely intermediaries. The court held that they are themselves the supplier of actionable claims for GST purposes. Fourth, the taxable value is not merely the platform fee or commission. Instead, the entire amount staked by players constitutes consideration for the supplier. Fifth, the court upheld the constitutional validity of Rule 31A and also ruled that 2023 amendments were clarificatory in nature and therefore retrospective. Finally, the Supreme Court set aside the High Court decisions that had quashed the show cause notices and restored the proceedings for adjudication under the applicable valuation rules. So, what are the practical implications? GST liability may now arise on the entire stake value instead of only the platform fee. Earlier show cause notices that were quashed can now proceed further. Constitutional challenges against Rule 31A and related GST provisions have been rejected. The judgment will significantly impact online gaming companies, fantasy sports operators, casinos, and other similar digital platforms. Business operating in this business sector should immediately review their pending litigation, tax positions, valuation methodology, and provisioning requirements. The Gameskraft judgment is undoubtedly one of the most significant GST rulings since the inception of GST. The Supreme Court has clarified that online gaming involving stakes is taxable on the full value of the stake, upheld the constitutional framework of the levy, and restored pending tax proceedings. This decision is likely to influence not only the tax litigation but also the future business models of India's online gaming industry. Thank you for watching. If you found this analysis useful, don't forget to like, share and follow for more updates on important GST judgments and tax developments. See you in the next GST update.